Good morning to everyone. The first case this morning is Moats versus Republican Party of Nebraska. This is further argument on this case. Mr. Domina, good morning.
Good morning, Your Honor. May it please the Court. I'm Dave Domina. I'm here on behalf of Rex Moats. Your Honors, the First Amendment is not a pleading rule. And pleading's rules are not liars' tools. When Mr. Moats filed this case, his first paragraph in his complaint read in its first sentence, "False statements made for any purpose are abhorred by the law. Knowingly false statements made with actual malice or wanton disregard for the truth are defamatory." On that day, Mr. Moats knew of the United States Supreme Court's decision in Twombly versus Bell Atlantic. He did not know of the decision that would come down that year in Iqbal versus the Attorney General. He anticipated that this court would be working on pleadings issues, and you've now pronounced Doe versus Board of Regents. He understood that the pleading standard might become one requiring plausibility, and it now is one that tests his complaint against a plausibility standard. Mr. Moats wanted to plead and wants to try a case for defamation. So in his complaint, he carefully included the elements of proof. And he included the elements of proof of both defamation per se and defamation per quad. He did that by carefully outlining the fact that he could prove how the defendant operates, what it publishes, that its officers include lawyers who engage in practice in bankruptcy court, as he alleged in paragraph 18 of his complaint, and that the actual facts that would prove that the statements made against him were demonstrably or provably false, using your language in Wheeler versus Nebraska Bar Association, could be established by looking at that bankruptcy file, the file involving his employer, National Warranty. That specific and careful pleading was designed to assure that Mr. Moats could stay in court, even if plausibility became the pleading standard in Nebraska, which it now has. He believes that those allegations are sufficiently specific so that his pleading establishes on both per quad and per se theories that the statements made against him, and particularly those saying that he lied in an affidavit filed in court and thereby committed both a crime and a disbarable offense, give him the right to present this case to a jury.
When you say that the publications state that he lied in an affidavit, to which publications are you referring?
3 and 4, Your Honor. Those are the two in your order for supplemental briefing and argument, and I am focusing entirely and exclusively on that point, on those two.
Okay. And do either of those use the word lied?
No, they say false, that his affidavit was false. Each of them says that. Each of them accuses him of a falsehood.
Is that by misleading? Or
I'm sorry, does it say the word false? Does it say lied? Does it say misleading? Just getting kind of specific about the publications.
In connection with publication number 3 on page 7 of the complaint,
right,
we quote the publication as saying, "How did Rex Moats mislead creditors and the public?"
Okay.
That's the question posed in the publication. The answer given in the publication is Rex Moats claimed in an affidavit that National Warranty was doing well financially. We go on to describe, not quoting, the falsity in the rest of the publication.
So what I'm trying to do is just initially focus on the words of the publication. So the publication uses misled. and affidavit. Is that correct in number 3?
That's correct. It uses those words, and we quoted only a portion of it. In connection with publication number 4, we cut, pasted, and put one of the two-sided postcard in the pleading.
Okay, so that's that, I'm sorry, number 4 is that fanciful postcard.
That's correct.
Like
the one that
a
purports
postcard from an island.
that purports to have been written by Mr. Moats.
Right, okay. And the language in number 4 is misleading statements in an affidavit, is that correct?
Yes.
Okay, that's the exact language of the publications.
Have made misleading statements in an affidavit are the words in that document. Yes, Your Honor.
Okay, so
Is
your
there-
argument is that those words are the equivalent of lied and false?
Absolutely.
And that's why you say it's per se.
Absolutely.
Is that the logic of it?
That's the logic. And a review of this court's disbarment opinions will disclose readily that you have disbarred persons for lying on language that is the functional equivalent of that. There's a federal bankruptcy fraud statute that would attack a false affidavit with false language or misleading language. There's a state perjury statute that will do it. There's a definition of the term affidavit that does it. And Mr. Moats has no way to get any redress about what he was called and how he was marked except to have his day in court.
Let me direct your attention to publication number 4. That has been characterized, I believe, by Mr. Graz as political satire. Is there a legal concept of political satire, and is that protected by the First Amendment?
I think the answer to that is no, Your Honor. There is a legal concept of political speech. It's clear that's the most highly protected kind of speech. Satire is a form of speech, but what is legally recognized is political speech. Political speech has constitutional protection unless the party who claims to have been defamed by it can establish an element of proof imposed on the pleading and proving process by Sullivan versus New York Times, which is that we have to prove, after pleading, that the publication was actually false. In this case, we have pled the publication, and we have pled the precise location at which the truth exists in a United States bankruptcy court file in the District of Nebraska. So in this case, we have said, you've accused us of a false affidavit. If you would have conducted a minimal investigation in a public record, you would have found your statements are false, and here's where the proof is.
I believe Mr. Grass also characterizes both publication 3 and 4 as being opinion. What is your response to that?
Our response to that is similar to the one I just gave, but not identical, Your Honor. Opinion is not protected speech. It can be political speech, and political speech is protected speech unless the element that I just described from New York Times versus Sullivan is satisfied. The fact that something is an opinion does not make it non-factual and non-defamatory if, in the context in which it is uttered, it can reasonably be mistaken as fact, and that's true of both of these publications.
Well, the Republican Party, the way I read their briefs, is that context is critical, and a reader would understand this to be either hyperbole or whatever, satire, and with that publication 4 and the depiction of the island and the palm trees, that you have to read all that, and a reader would say, well, this is just typical political satire or hyperbole.
Yes, I know that's the Republican Party's position, Your Honor, and I respect that it is. My response to that is that a great deal of the public believes a great deal. It was well into the second millennium when the Pope of the Catholic Church believed the earth was flat. There are people in this country who believe that taking some sort of over-the-counter medication is a cure for cancer. But there are rational people, not always highly educated and not always with master's degrees in political science, who think things through and don't get to that conclusion. The Republican Party is not entitled to the benefit of the doubt on that. It defamed this person by calling him a liar in an affidavit for all practical purposes, though it didn't use the word liar, and it's not entitled to get out of it because now it says, didn't we use a cute palm tree on the publication?
How important is the fact that the misleading statement is in an affidavit because an affidavit is a word of art? It's a special kind of piece of paper.
Your Honor, I think it's important because it makes your work in this case easy. If it weren't true that the allegation against Mr. Moats was that he made false statements in a court document and in an affidavit, I could not say to you that these are accusations of criminal misconduct. I can here. That, I think, makes your work easy. Thank you very much.
Thank you.